Okay, well, we got another witness. We got another setup. Linda's gone. She's going to be coming back to host at 3 o'clock. Gene, I don't know. It seems like really laborious in court. I know, like me, you are a tactics guy in terms of doing things in front of a jury. If my trial partner were doing this, I'd be losing my mind.
Yeah, and you know what? I got to go back to a previous witness. What I used to teach my baby prosecutors for the mundane stuff, the foundation, the chain of custody stuff, you have to get that done in a New York minute because jurors are going to literally fall asleep. And the previous witness, remember he got out of this witness stand and he's looking at the chart where his house was? Remember that?
Yeah.
And he didn't know where it was, and it took like 5 minutes. You know what that told me? The prosecutor did not prepare that witness. That was painful.
Yeah, yeah, and then all the authentication of the stuff, and I'm told these videos really don't really show anything, so we don't really know the reason for that. We got this witness on the stand. I mean, if we're having to take all these breaks, the good thing for us is that I get to talk to you and Linda while we wait for them to put their case on in front of the jury. And jurors can get frustrated by that because there's an ancillary issue there. It may appear, I'm not there, I can't say, but if you're not doing things right, they may start to lose faith and trust in your judgment about the case.
Absolutely. If you are sloppy and disorganized and you're just very laborious, a jury's going to lose respect for you. But if you're a lean, mean machine and efficient, they are going to say, this guy, Gene Rossi, he's worked hard on this case, he believes in the case, and he's trying to make it fast and efficient for everybody. I do want to add this, stipulations. I used to try to get agreements, stipulations with the other side. Hey, this videotape, do we have to go through 5 minutes of foundation? The drugs that were seized from the search warrant, can you just stipulate that these are what we purport them to be? That saves so much time.
Well, Gene, one last thing I want to ask you is at least how I do it, how I was taught. It's not that Bob Bianchi invented this, but my files are organized. They're in a box. The name of the case is on it. I have my evidence book, my court rules, the criminal code that's there. I have my Crayola crayons at counsel table. I may not even use these things. My exhibits are ready to go. They're pre-marked, and we're moving very quickly. And I'll tell you why. My friend served on a death penalty jury one time and actually told me that the conversation in the jury room that went on was how organized the prosecutor was. Not me, it was some other prosecutor, and how they just inherently trusted that prosecutor based upon the preparedness and not so much the facts, which actually bothered my friend.
I can give you a war story. In Springfield, Illinois, all right, in 1992, it was the end of the first day, and a local prosecutor, came up to me in the U.S. Attorney's Office. I was flying in from D.C. and said, Gene, can you do me a favor? I go, what? Your counsel's table looks like a junkyard. You look like a hoarder. You look disorganized. And I spent the next 20 minutes cleaning my table because I wanted to show the jury that I was organized. I never forgot that. That was 1992.
Yeah, I mean, these are the little things that you learn, and when you're teaching the tricks of the trade, you want people to be tidy, you want them to be clean, you want to explain the psychology of what goes on with the jurors.
Also, you brought up attire. When I appeared in front of a jury, I had a nice tie. I just looked professional. Mm-hmm. Mm-hmm. And because they expect that from a prosecutor and also a defense attorney. If you look like you went to a consignment store and just got an outfit for the opening and closing, I don't think they're going to have respect for you. That's reality.
Gene, I agree with you completely, but when I was a baby prosecutor, my supervisor actually complained I dressed too nice and that you should look like, throw your coat on the ground before you do it. Prosecutors shouldn't look good. I disagree with it then. I disagree with it now. I agree with you. We're going to go to a quick break. We'll be right back. Okay, welcome back. We're in the Baptista trial. What you're seeing on your screen is some crime scene video. It's very dark. There's not much testimony going on. So me and Gene, if you don't mind, I mean, in terms of crime scene investigation, you see right now there's a stop sign. That is obviously the spot where, let me get my glasses on, Tara Road and Miramar, yep, Parkway. This is where the incident took place. This is where the allegation is that Elder and Baptista had left his party, were at that stop sign when the victim, Knight, drove up behind them, got out of his vehicle, and then the issue begins as to what was this? An attack on Baptista in retaliation, or was this the victim, Knight, coming out to shake the hands of these guys and have a gentle encounter, and they just ambushed them? But there you see it. From the video perspective of where these cars were. I always find crime scene video, Gene, I made them videotape every evidence, not just photo document it, but videotape it as well. I think what we're looking at right now, Gene, is, I would imagine, blood, secretions on the road as to where the attack took place. It's a little difficult for me to see if that is actually, that is a hat. Okay, you know, these are the real life consequences of the aftermath of somebody dying. The issue in this case, is it a manslaughter or is it a justifiable self-defense case? I think we're looking at some money there. There's all marker tags all around, so there's various pieces of evidence that crime scene investigators will photo document and video document prior to those things being removed, so that there is a record of exactly the placement of all those things, and also, Gene, to show that the scene was properly preserved and analyzed by crime scene detectives.
And the other reason they're doing this and showing this is jurors are going to say, okay, this happened at the stop sign at Terre and Miramar. Well, why didn't they take photos? So I've had cases where we didn't take good photos, if at all, and the defense would always say, what a sloppy investigation. They didn't even take photos. So even though this video is relatively unremarkable, except for the blood and all that, because it doesn't show any, body, jurors want to see that. They want to see that you've done a good job and tried your best to collect as much as you can.
Gene, that is an excellent point, because it goes to what in most states, and we have to play by rules. We have to play the game by what will the judge charge the jury at the end of the day about the crime. And one of the things that happens in most states is the judge says you can find a person guilty or not guilty based on the evidence or the lack of evidence. Or if you would have expected the police to have done something that they didn't, it may compromise the investigation and therefore, in your mind, affect whether or not you should acquit the defendant of the offense. So you need to be proactive as a prosecutor, is what I'm hearing you say. And it may not necessarily be relevant, but you don't want to hear that you were sloppy and didn't do something and have the defense lawyer, then stand up and say, they're no good, they didn't do it right, you can't rely on their conclusions.
Right. And I just thought of the CSI instruction, crime scene investigation instruction. Prosecutors, after that show started, they would, even at the federal and state level, get the judge to give a CSI instruction. In other words, this is not TV. This is not a perfect world. We don't expect and require the prosecution to put on DNA evidence in every case. That was the CSI instruction.
Gene, I go back to the days when I started trying homicide and high-level, high-profile cases. We didn't even have DNA. I mean, I think it was like new, and if you wanted to get the sample at Quantico, you could make an application. I was trying murder cases where we had blood evidence, and we couldn't get them in the day to even do DNA evidence for that. And you know how we tried it? The good old-fashioned way, with witnesses, arguments, circumstantial evidence, and we won those cases. But today, if you don't have DNA or scientific evidence, to your point, the jurors have that CSI effect. They don't have the stuff I see on TV.
And when I did my cases towards the end, especially after that show, I would bring out in my trial in opening and closing, or my colleagues would, that here's why we couldn't get this. Here's why we couldn't get this evidence. Fingerprints on a gun.
Yeah, I was just going to say that.
Explain why, sir, expert, why you couldn't get prints on a gun, and they would explain that, and the juries loved it.
Right, and there are many times when we talk about that controversy, you see the defendant now in court. Again, we'll let you know when something significant is happening. But, when we try to explain on the lawyer side to the cop side that, yeah, I know you're not going to get fingerprints off this piece of evidence, but I need you to do it so that I can at least argue we did it. Nothing developed from it, as opposed to hearing in the courtroom that we were sloppy and didn't do something that could have been the case cracker, because that's what the defense will say.
Absolutely. Absolutely.
So, Gene, this is why I love having you on, because these trial tactics, this stuff makes a big, big difference. I've seen cases lost by prosecutors on the very fingerprint question that you asked, and after they're not guilty, the jury comes out and they were like, yeah, the defense was right when they said, you know, where are the fingerprints? Why didn't they do fingerprints? And keep in mind, here's another little nuance for our audience, because I know they love it, especially those guys in the chat room. I can comment on that as a defense attorney, but you can't, as a prosecutor, get up there and say, well, we didn't do it because of this reason in summation, because you didn't bring it out during the testimony.
Right, exactly, absolutely. But are they playing this whole video, Bob? Now they're kind of, this is getting to be a little lengthy.
Yeah, so we have, we're seeing various clothing, items of clothing. I personally, Gene, think that this is actually a good thing to do, because it kind of brings, for the prosecutor, brings the reality of the crime scene and, and the basics of the blood or whatever. I just think that even if it's not necessarily wholly relevant to the case cracker, it's always good stuff. But listen, we have a clip from earlier today, an officer, Yamed Yema, from the Miramar Police Department. Let's listen to that clip and come back. And of course, if court opens up with anything significant in this case, we're going to get right to it. Okay, welcome back. Gene, we were talking as the prosecutor, as the defense lawyer is cross-examining here. He is scoring some serious points to the theory of the case. Kind of gets me back to the other question about confirmation bias of prosecutors, in that he's showing physical evidence that doesn't make itself up. It's independent. It doesn't have a motive. It doesn't have a point of view. It is what it is. Blood inside the motor vehicle, inside the door, and this infamous beer bottle with glass broken on the inside passenger seat, and even blood on the console of the center of the vehicle, as well as outside, consistent with what the defendants are saying was a struggle that occurred inside the vehicle and spilled outside.
This case, I would have said, members of the jury, the most important witness in favor of the defendant was not called by us. It was called by the prosecution sitting at that table. Officer Lisa Cruz proved our case. This man, Mr. Knight, who was a victim, he walked up to that passenger door and beat the living daylights of my client in the head, and there was glass and blood all over the place. That's what we have been saying since the beginning.
Right, and then you wrap that around the common sense piece that it's, to me, I just keep saying it over and over again, it's him, and the witness is now getting off the stand, so he gives us a little time. It's Baptista and Elder that are leaving this party where there's something tense going on. And we saw the intersection through this very witness, like you've indicated, where the blood is on the ground. They're at that intersection when the victim is coincidentally leaves the party after them, after that tense encounter. It is now behind them, and according to the victim's girlfriend, who has a reason, a motivation, whether truthful or sometimes people just have a way of seeing things favorable to themselves, says that he gets out in the middle of the night just to shake the hands of these guys at the stop sign. And when it's all done, you have all this blood and glass inside the defendant's vehicle, making the argument as a defense attorney, our clients were the ones who were the victims here.
Absolutely. And Mr. Knight possessed a deadly weapon. A beer bottle can be a deadly weapon. And when the spout off of a beer bottle is broken off, that means that that bottle was used to hit somebody on the head and possibly kill them. Therefore, my client, Mr. Baptiste, had a right to defend himself, and he used a knife, and tragedy happened, and Mr. Knight died. But that doesn't mean my client's guilty. There's the case right there.
Excellent summation, counselor. I appreciate it. We're going to run to a break, and we'll be right back. Okay, just so we're clear, that was the Elder, Mr. Elder, who was a defendant in the case. He got found guilty of a high misdemeanor, carries no more than a year. The reason you're seeing him cuffed, in my opinion, Gene, is that he was already in custody. He was about to do a time-served sentence. He had been convicted of an offense, even though it was a low offense, in my opinion, a loss to the prosecution, at least as we score it. And you could see the dissatisfaction on his face as he shook his head when he got convicted of the misdemeanor. Probably him and the defense lawyers thinking it was a compromise verdict.
Absolutely. And, you know, the look on his face suggests that, you know, some defendants kind of put on an act. He looked like I shouldn't be convicted of anything. This guy came up to our car. He had a beer bottle. He wanted to kill my friend, Mr. Baptista. You know, I shouldn't be convicted of anything, even if it's a misdemeanor.
Yeah, Gene,
So,
yeah, I agree with you. It's funny how beyond words, the nuances of a facial expression and the manner in which somebody sits in their short. There's so much we take for granted. Look at him there. You could just see in his eyes his head going down. I believe that he's not being arrogant. He's upset he was convicted of anything.
Hey, Bob, I want to go back to the Zachary Keene case. When the prosecutor was doing her closing and she was talking about choice and acts and omissions, I got the impression that defendant's going, you know, I kind of agree with her. It was a bizarre feeling.
Hey, Gene, let me ask you a question about this case. It's funny. You have the Elder trial. Now we have the Baptista trial. We have two separate juries evaluating the same factual situation, if you will, the same players, the same evidence, the same videotapes. What would you say if there was a completely wildly different verdict, like a guilty of the manslaughter? Would that concern you as a prosecutor that one jury saw it one way? I know they're different people and supposedly had different levels of culpability, but let's say the same defendants tried a second time. One says they can't come to a conclusion or not guilty on most things, and another jury looks at it and says guilty on everything.
You know, it would bother me a lot because that's why you want a trial with all defendants, whether it's 2, 3, or 4, because you got the same jury, you got the same judge, you got the same prosecutor. There's like a level of fairness. When you have two different trials against separate defendants, you know, one prosecutor could have been good or bad. The other one's much better or worse. Same with the defense attorneys. The jury, Bob, you don't know if you're getting a good jury or bad jury. Elder probably got a good jury. That's why it was a compromise. Baptista may get a bad jury and say, you know what, that dude should be convicted of manslaughter.
Yeah, jury dynamics are a huge point. Well taken, Gene. Listen, let's go to, I think the person who's got the burden of proof, obviously, is the prosecution, proof beyond a reasonable doubt, to 12 jurors on a case that I think the facts are certainly arguable for the defense. So let's listen to the prosecution opening and see how they're pitching it to this jury. Okay, Gene, Rossi. Yeah. Listen, we've been good today. We've been saying some lawyers are doing some good lawyering, and we haven't been, critiquing. But let me ask you, first of all, I don't think in half of a career as a prosecutor, I have ever used the word puzzle to explain my case. I mean, you don't want it to be a puzzle. You want it to be, okay, so I'll go with mine. Let me get it out, okay? Get it out, Gene. You know how we do it, right? You know, it's Serenity Now. And if we prove it to you, as opposed to we will prove it to you. And lastly, what I don't have to prove, motive, and I don't have to do this, I have to do that. You might as well tell them I don't have that evidence for you.
Here's the thing I used to tell baby prosecutors. The words that you use in your opening and closing and your body language are profound moments in a trial. And I want to talk about her words. You just brought up her words. Puzzle drives me nuts. It's 50 fingers on a chalkboard.
We got 15 seconds, Gene.
Yeah. Also, her body language. She was tentative. And did you look at the body language of the judge? He didn't like her opening. And you can guarantee the jury's looking at the judge, who's not looking kindly on the prosecutor, who was sustained about 3 times, by the way.
And that is always deadly to have a judge. The jury really looks towards that. I got to go. Linda Kenny Bottom's coming back. I'll be back next Monday. You be well.